Esteemed members, good evening. Thank you for joining today's webinar. If you can hear me, just send a message on the chat and let us know which PSK branch you're joining us from. Good evening for those who've joined. Dr. Gideon, Dr. Peter Mburu, Dr. Simon, Dr. Brian, welcome. Thank you, Dr. Nderitu from Nairobi branch. All right, thank you for your confirmation. Dr. Ochel from South Nyanza, Dr. Poonam from Nairobi, Dr. AJ Patel from Tana Adi branch. Thank you for your confirmations. So as we wait for our starting time, I'd like to kindly request you to subscribe to the event on the PPB portal. The keyword for this event is data protection, and you should be able to find the event. So kindly ensure that you subscribe early enough so that you can get your CPD points on time. Santeni for joining. I see representatives from South Nyanza, Jason. We have Tanadi branch, Dr. Kimani, Dr. Kigathi from Nairobi branch, welcome. Dr. Ngetich from Bomet County, welcome. If you haven't, kindly ensure that you've subscribed to the event on the PPB portal. And remember, you don't have to send your email address on the chat. Once you attend, your attendance is already recorded by the system. So you don't have to send your email address on the chat. All right, so I see we have a good number, 340. So once again, thank you so much for joining today's event. This event has been organized by the PSK Legal and Ethics Committee. And the topic for the day is navigating the Data Protection Act of 2019. And we'll be delving into the implications and best practices for pharmacy professionals. And our speaker for today is Dr. Ashna Maru, who's a data protection coordinator for the Philips Pharma Group. And aside from that, she also practices as the regulatory affairs pharmacist at Philips Therapeutics Limited. So once again, if you haven't subscribed, kindly do so. Use the keyword data protection, and you should be able to get the event easily on the PPB portal. And just a reminder, this session is being recorded and it will be made available on the PSK YouTube page. And if you have any questions, I'd like to encourage you to use the Q&A tab. That way it will be easier for us to track the questions and have them responded to. So just a highlight of the agenda, we'll be having a few remarks from Dr. Libea Bethwell, who's part of the Legal and Ethics Committee of the Pharmaceutical Society of Kenya. Thereafter, we'll have Dr. Ashna Maru coming in to give the presentation. Then we'll have a Q&A, and then we'll have the closing remarks. So at this point, I'd like to welcome Dr. Libea Bethwell to give some opening remarks on behalf of the LEC committee. Dr. Libea.
All right. All right. Dr. Hazon, confirm if you're able to hear me.
Yes, loud and clear.
All right, thank you. Esteemed colleagues, on behalf of Dr. Juliet Konje, who is the chair of the Legal and Ethics Committee and the whole Legal and Ethics Committee, allow me welcome you to today's webinar on Data Protection Act 2019. And I won't dig deep into the topic, but the committee saw it fit that it's something which is timely for us as pharmacists because we interact a lot with the patient data, and either cause of commission or omission, we may find ourselves on the other side of the law and end up being penalized, and yet is something that maybe can be avoided if we have the correct information. So the committee saw it fit to have this particular webinar so that we can get enlightened on how best to handle patient data and any other data that when mishandled may put us on the wrong side of the law. So feel very much welcome, and I hope that you learned something from this webinar that shall better your practice as a pharmacist in whichever space you find yourself. Over to you, Hezron. Hezron, over to you.
Sorry, just found myself speaking on mute. Thank you so much, Dr. Libert, for that brief intro. So at this point, I'd like to just welcome Dr. Ashna, who will be the speaker for the day. Dr. Ashna, if you can hear me.
Yes, Dr. Hezron, thank you. Can I share my slides?
Yes, please.
Okay. Just confirm if you can clearly see it.
Yes, it's okay. You can go ahead.
Okay. First of all, I would like to thank you, PSK, and Dr. Hezron and Dr. Bethel for introducing me and giving me this opportunity. I'm privileged to be giving an insight on data protection, the act, and the implications as pharmacists, whether we are handling distribution, whether we are handling a pharmacy or whether we are basically a manufacturing unit, we are all going to be having implications if we do not comply with the protection. So I will take you through what exactly is data protection. So it is basically referring to the legal and organizational measures that we have to take in order to safeguard personal data from unauthorized access, misuse, and breaches. We have two types of data. There is the personal data and we have the sensitive personal data. Personal data can be information that can identify an individual. Example, names, ID numbers, physical addresses, email address, phone numbers. While sensitive personal data includes health data, biometric information, genetic data, religious beliefs, sexual orientation, or political views that requires enhanced protection. So we need to understand the types of data that's personal and sensitive, and what are the different aspects that involve these two kinds of data. We all wonder, when I got this opportunity, even I wondered, why is data protection so important? Because this was never really an occurrence before all throughout history. So we need to understand that it ensures privacy rights as it needs to be respected. It also prevents identity theft, fraud, and other unauthorized access to personal information. And last and the most, to build a relationship with your consumer and as a authorization holder, it builds trust between businesses and customers. So in the future, you can obviously have a good reputational background that no, this entity is trusted because they know how to handle sensitive data that may or may not be, misused or cause a breach. Then let's look at the Data Protection Act of 2019. This is just a very brief summary what I've shown on the slides. But if you Google the Data Protection Act of 2019, it's quite a few pages, but if you read through it, it actually gives us all the information that requires us in order to be compliant. So it was enacted in 2019, and this law aligns Kenya with global standards such as the EU General Data Protection Regulation. And the main objective is to protect the privacy of individuals by regulating how personal data is collected, used, stored, and shared. It specifically applies to everyone in the country, but as us as pharmacists, I'm going to talk on that area. It collects or processes personal data in Kenya or about Kenyan citizens. So we are in the middle of the healthcare chain. We have access to so much data that comes to us. We could be an LTR, we could be a manufacturing unit, we could be a pharmacist in the chemist. We do have access to all sorts of data. Hence, as Kenyan citizens, we need to understand how to process this personal data. The key provisions that include in this act is consent, data minimization, data accuracy, and data security. What exactly is consent? So consent is when personal data is collected with explicit informed consent from the individual. So if I'm going to be using your information for some purpose, it is important to have a disclaimer or some form of consent from the people you're associating with that, yes, I have given you consent to this particular data you have about me. So in the future, if we do get audited, or if we get a situation whereby we are questioned, we can show them proof that there was consent taken for this. There's data minimization. Basically, you can only collect data that is necessary for the specified purpose. If we are in a situation where probably we are taking orders of getting specific medications, and sometimes some medications are not supposed to be stocked as a whole. Maybe you can only order a few quantities. So certain distributors require prescriptions from doctors. It would be better if we can try to avoid giving out full information about the patient, the IP number or anything, rather just have the prescription which has the product written on it, those sensitive informations for sensitive types of diseases. No need to share prescriptions as a whole to people out there to order for certain drugs that you probably don't stock as a big quantity. So that's what data minimization is. Only share what's required, and what other information there is extra, it is very important to try hide that information or have it very minimized. There's also data accuracy. Data accuracy ensures personal data is accurate and it is up to date. We do not want a situation where, for example, we have somehow written some wrong kind of sexual orientation of a human being. We need to have correct and accurate data. Then there is data security. It implements the appropriate technical and organizational measures to secure personal data. For example, how on our desktops, if we are using it, the way we have a password or a passlog before anyone even accesses our desktops. Similarly, some critical data is stored, it would be very advisable to have it encrypted. So very few people can access it, and whoever accesses it is basically having some form of encryption needed to be able to get that information. Then we have rights of data subjects. We also have to understand, like I just told you about, access, correction, and erasure. So access is basically individuals can access the personal data held about them. Every individual's personal data that is taken, they have full right and access to know what data of theirs was taken. Correction, individuals can request rectification of incorrect data. They have the full rights. As us civilians, we have that right. And erasure, if I don't want certain data of me held into the system, I can ask for it to be deleted. And it is completely normal to be done because these are the rights of, as normal civils, we have to do this. Then we have to look at the fines and the penalties for non-compliance. This is a very, very important thing we need to do. And I have seen a few cases that have been fined over data breach. So the financial penalties are, if an entity violates the provisions of the Act, they can face fines of up to cash 5 million or 1% of their annual turnover. whichever is greater, basically. Then these penalties may vary depending on the severity of the breach and the number of the individuals affected. Let's note on that as well. Then there is the criminal liability where offenders can face a prison sentence of up to 2 years, depending on the violation, particularly if it involves sensitive personal data. There is compensation as well. Individuals affected by a data breach can seek compensation for financial or emotional damages through legal claims. It's very much a thing, and I've seen people do this. And what last comes to last is reputational damage. The effort and the time and the years we have spent in building a good reputation with our consumers, it goes beyond fines. The organization risks the loss of trust and reputational damage, which could significantly affect business operations, especially in sectors like our healthcare sector. So this is a very important area where we have to be very careful. I'm going to talk about a few key areas where I have seen in my experience where data protection is very, very essential, especially in areas where sales and marketing is involved. So I know in the healthcare sector, we have so many chains in the healthcare sector, which we could be operating anywhere. So areas where we are doing sales and marketing, we have to have a lookout for customer information, whereby how is the role of personal data in sales and marketing related to customer information. So the first thing I would like to go over is a pharmacist often collects personal data like phone numbers, email addresses, and purchase history for promotion and loyalty programs. This kind of information is called customer information. Then there is areas like targeted advertising. Personal data is used to send product recommendation, promotional offers, or health advice. We could see that our patient is suffering from XYZ, and because we know this product of ours is a very essential product, we use this person's personal data suffering from XYZ to promote one of our products. This is called targeted advertising. Even if you do such an area, or if you do use such a strategy, it's very important to know that you have taken consent from your customers, from your patients. So tomorrow they don't go and like complain or file a complaint that we have done a data breach. Then the other part you have to understand is what are the data protection requirements? What are the strategic steps we can do in order to avoid a breach? Number one, consent, which is very, very essential. Customers must explicitly agree to receiving marketing communication. Pre-ticked boxes or implied consents are not allowed. A proper disclaimer whereby they have accepted and agreed that their consent has been given for such areas or such targeted advertisements. There's data minimization. It's obviously, I said even before, only collect the data necessary for marketing purposes. Example, you do not need to have unnecessary health information. If you're going to market paracetamol, why do we have unnecessary health information that a person has a genetic mutation of XYZ? It does not relate. Just try getting the targeted area of where you want to market it. No point having the unnecessary health information about the patient. Then we have to have an opt-out mechanism. It provides an easy way for customers to withdraw consent, example, unsubscribe to links in emails. Sometimes patients are not comfortable with giving out consent for every small thing. So it's always good to have subscription emails where if they want to like withdraw their consent, they just need to unsubscribe from their link. So those are areas where we can work on. Then there's consequences for non-compliance. Misuse of customer data for unsolicited marketing could result in fines or loss of customer trust. So those are the consequences we can face. Then there's also areas where we have to understand the data protection in order management systems. I talked about sales and marketing. The other key area I would like to focus on is order management systems. As every entity, whatever we are handling or whatever our business is, we do have an order management system. We do place orders for certain medications to arrive or anything rather. It's very important to know that personal data in order management is actually noted. So the first thing is what kind of data is collected. I know I've seen it personally. Name, delivery address, contact details, payment information, and prescription details have been used. They have been collected. The data it's used to process orders, manage delivery, and maintain customer records. This is perfect. This is fine. It is part of our order management strategy system where it is important. However, we need to have the key considerations as to how and why and the areas where we can have security measures that if someone comes in tomorrow, they won't have access to such data. So the key considerations we looked at is secure data storage. So pharmacists must ensure that customer data is stored securely using encryption and other technical safeguards to prevent unauthorized access. I think that's very much easy to understand. Access control is basically it limits the access to some sensitive customer data within the organization to only authorized personnel. It's better to give access to one person rather than giving access to each and every individual in your firm. There is data accuracy as well. Ensure that the customer data, including addresses and contact detail, is kept up to date to avoid issues in order to fulfillment. Sometimes what happens is because we don't have up-to-date delivery addresses or contact information, because we have old data already stored in our system, we may end up sending a certain product to the wrong location. It is a data breach as well. Then examples of breach risks. Let me give you an example of a breach risk. So a data breach exposing customer prescription details or payment information can result in heavy penalties and harm the pharmacist's reputation. This is actually a breach. This could be a complaint. It could be, you could be fined. This is something everyone needs to be very careful about. Then we need to understand the impact on community healthcare and pharmacy. This is quite important and it is quite a big risk, especially community healthcare providers. So we need to know that sensitive nature of the healthcare data, like health data, is classified as a sensitive personal data under the Kenya Data Protection Act of 2019. This includes prescriptions, medical records, and consultations. This is classified as sensitive data. Why does this matter? This matters because a patient is high at risk. There is that level of confidentiality when sharing personal data information with healthcare providers, including pharmacists. I would suggest it's better to take some form of consent on such areas as well, because as patients, we are trusting our healthcare providers for us not to probably leak this information out, even if it's unknowingly. The key data protection concerns are basically confidentiality, consent for data use, and again, data minimization. So before I even go there, there is that area where we have to look at prescriptions, medical records, and consultations, like I mentioned. So prescription would be where our information about medication history and current treatments are included. Certain areas, sometimes we could be having prescriptions or medicines that we are taking could be for a very ill or very severe condition, which we do not want to share it out with people because of stigmatization. Hence, we do not want everyone to know about this. So consent for such areas, confidentiality for such areas is very important for us as community healthcare practitioners to be able to manage. Medical records such as details about diagnosed conditions, allergies, and treatment plans. Sometimes it's so easily available that it can actually be a data breach, just that people out there are still not very much aware about this data protection. And as much as people are getting educated about this, they're becoming more aware about this, because this is actually not complying through the act. Then let's go through confidentiality. So the main concerns in community healthcare is confidentiality. So pharmacists must ensure that patient health data is not shared with unauthorized parties, whether through conversation or data storage. I can give you an example where a patient discusses their health condition in the pharmacy. Today a patient comes and he or she starts discussing with you regarding a certain condition. As us healthcare practitioners, as us pharmacists, our conversations should be held in private areas or that staff are trained to prevent accidental disclosures. You see, patients come to you with trust that you will maintain their confidentiality. So we do not have any right to, go and blab about this to someone else. And if you're going to have a one-on-one, have it in a private area. And if not, if you cannot do that, then make sure the staff around you are educated and trained enough to know that this data cannot go outside then the four walls of that place. Then we have consent for data use. This is very important in any facility. In a community pharmacy setting, it is critical to obtain explicit patient consent before sharing any health-related data with third parties, including insurance providers or other healthcare professionals. Another example I can give you, a pharmacy needs to probably submit prescription details to an insurance provider for a reimbursement. The patient must be informed and consent to this data sharing. The fact that this prescription is going to your to your healthcare insurance, have you as pharmacists been able to take consent from your data for such kind of sharing information? Have we done this? This can easily be caught as a data breach. I hope you guys have noted this down. Then there's data minimization. It's necessary, or I rather say mandatory, to collect data that's necessary for providing healthcare services. Avoid asking for or storing additional personal details that aren't directly relevant to your patient's care. Why? Why do we even ask for such information? I can give an example in a situation where a pharmacy may only need a patient's prescription history and contact information. Only history and contact information. So asking for extra data like national ID numbers or family history without reason violates the principle of data minimization. Why are we asking these extra things? Phone numbers, email addresses, ID numbers. What is your family's history? Does your family history have does he have hypothyroidism? This is unnecessary data. This is basically non-compliant to our data minimization concern in this community healthcare setting. So it's very important to make sure these three areas we are focusing on and are compliant to. I would like to talk about, there was a recent case on August 6, 2024. The Office of the Data Protection Commissioner published its decision in complaint number 280 of 2024, and it issued an order where company X had to pay a fine of that amount as compensation for unlawfully processing health data following a complaint. So what happened was, it was something quite significant. It was a significant data breach. There was a situation where a customer's sensitive health information was basically mishandled. So the company attached a label to a prescription delivery package, and it displayed the customer's full name, phone number, home address, and an incorrect medical diagnosis. This information was not only exposed to the delivery rider, but also to others who may have not seen the package, who may have seen the package during the transit. So handling of this data, the way it was handled basically was violated according to the Kenya's Data Protection Act of 2019 by failing to obtain explicit consent and failing to safeguard the sensitive information as required by law. Everything always trickles down to consent, because without consent, anything you do is a data breach. So that's one example where you can maybe face a data breach. Then there was this other newspaper article I've read whereby 3 firms were fined a total of 2.2 million. There was a hospital in Nairobi that has been penalized around 500K for using a man's image on a public signpost and different print media, including calendars, which amounts to commercial use without his permission nor compensation. So you see, there was no consent taken for this, and yet it was used. Hence, this was a data breach. A small and simple thing, if not taken care of, you can directly have a close down. You can even you'll be fined. And it's obviously no one wants this, right? Then I would like to speak about the risk specifics to community healthcare. This is when we have situations where we have unauthorized access to prescription records. So what happens is basically we have paper versus digital records. So I know most of us, sometimes we have our records filed in manually. Sometimes we have it stored in our data. So what happens is prescription details must be securely stored. A breach exposing this sensitive data could severely damage the reputation of the company, and it can lead to penalties under the Act. Then when we talk about paper versus digital records, many pharmacies use a mix of paper and electronic systems. Both must comply with the same data security requirements, such as restricting access and ensuring that data is safely stored and disposed of. So if you have digital records, have it encrypted. If you're using paper, try having it locked in a lock and key cupboard. And after a certain period of time, do you have a disposal strategy? How are you disposing it? Are you shredding it? So if a if a pharmacy uses paper records for prescriptions, this should be stored in locked cabinets, and it should have controlled access, and any records no longer than maybe 2 to 3 years must be securely shredded. So this is one way we can, lower the risks in a community healthcare setting. Then we have to understand the challenges for community healthcare pharmacists under the Data Protection Act of 2019. So handling sensitive data in small settings. I know community pharmacies often operate in close-knit environments where trust is very vital. A breach of data protection can break this trust, especially in sensitive matters related to health conditions. So the common challenges in compliance are basically training of pharmacy staff. So in many community pharmacies, staff may not be fully aware of their data protection obligations. There is a need for continuous education on handling patient data, including limiting verbal disclosure during public conversations. So example, a staff should be trained not to discuss sensitive health information loudly in public areas of the pharmacy where other customers could overhear. The second part I would like to talk about is the secure data management, like digital prescriptions and access controls. So with many pharmacies moving towards electronic prescription systems, ensuring that these systems are secure, example through encryption, is essential. Access control. It's important to note not all pharmacy staff should have access to sensitive patient data. The role-based access control system should be in place to ensure that only authorized individuals like the pharmacist or the pharmacy manager can access these confidential patient records. Then we have to realize that data retention policies are important as well. So you need to understand that retention of patient records is where pharmacies must establish clear policies on how long to retain patient data. Unnecessary retention of outdated records can expose the pharmacy to additional risk. Then we need to understand or have a strategy of proper disposal. So you have to ensure all patient records, whether it's digital or paper, are securely destroyed when no longer needed. No point handling in or keeping data or prescriptions or records that are not even required. You're just causing unnecessary risks for yourself. Then we have to understand the patient's rights in healthcare. Like I've already spoken, rights to access, and there's rights to erasure. So an example, a patient may request their prescription history to share with the doctor. The pharmacy must provide this information in a secure manner, ensuring the data is accurate. Sometimes you could get such requests. We need to understand that what we are providing is right, and however we are providing it, whatever method we are providing it, what are the secure methods we have used in order to not have a data breach. Then the right to erasure is when a patient stops using a pharmacist's services, may ask for their data to be erased. Today, I decide that I don't want to buy products from pharmacy X and I want to shift to pharmacy Z. However, pharmacy X has all my information and I don't want it to be there with them anymore. I will ask for an erasure. And us as healthcare practitioners, we need to oblige to this. That is part of the law. And it is legal because otherwise you can be fined for this. We are going to be violating the act. Then the best practices for data protection in community healthcare pharmacy. The first point is strengthen staff awareness. Conduct regular training on the Data Protection Act and its implications for handling sensitive health information. Develop confidentiality policies that guide a pharmacy staff on the appropriate handling of patient conversations and health data in public-facing roles. Then the second point is implementation of robust data security measures. One we could have is encryption of health records. The other one we could have is secure communication channels. If a pharmacy communicates with patients via email or SMS, these communications must be secure and compliant with data protection regulations. Depending on the method you're using, we must be aware on how and what kind of security measures are we implementing. Then there is the area of patient interaction policies. In this, we need to understand the protocols to ensure that patient data is handled discreetly in busy pharmacy environments. So we can probably train staff to avoid discussing this healthcare information with earshot of other customers. And maybe we can take the patient to the side in a more private setting and discuss whatever necessary with that patient. Then data sharing, data audits and reviews. So you have to conduct regular data audits to ensure compliance with the Kenya Data Protection Act of 2019. That's when I said, if you get audited by an external party like the DPER, and if you come across as you have probably had a breach, you will be fined. Hence, internal data auditing is very, very mandatory in order to pursue compliance. It's always good to review data protection policies annually and update practices based on the changes in technology or legal requirements. And overall, in conclusion, the Key Data Protection Act places a higher priority on safeguarding patient privacy, especially in healthcare settings. Pharmacists must be vigilant in how they handle patient data from the point of collection to storage and sharing, ensuring that they have explicit consent for any use of this data. And best is implementing best practices such as staff training, securing data systems, and clear patient communications can help pharmacists maintain compliance and uphold patient trust. I hope I have made some difference. Thank you.
All right, thank you. Thank you so much, Dr. Ashna. I think that was a very good presentation. I believe we've all learned something out of it. And I'm expecting questions now. If you have any question, kindly just put it on the Q&A tab so that she can respond. So there's one question from Dr. Mora, who's asking any ideas on how consent can be achieved for patient data kept in the community or retail setting?
For such a scenario, first of all, it's important to understand the patient and how efficient, not how efficient, how often does he come to you? Does he have third parties included in this, whereby maybe he will require you to be sharing the prescriptions for probably insurance for reimbursement, or would he be requiring you to be sharing your past record of his prescriptions or the condition he has with the hospital or with the doctor? So in such a scenario, it's important to take consent from this patient itself, telling him that in the future, if these scenarios occur, I want your consent. Or maybe you can have a form or an online form or a Google form where you show proof that this person had consented to this kind of information to be shared with the insurance holder or with the doctor. So in the future, if this patient comes back and says that you breached or you violated the law, you can easily be like, no, he had given consent for this kind of data to be shared.
Thanks for that. I hope your question has been answered, Dr. Mora. So the other question is, I see we have more questions that are popping up on the question and answer section. So we have from Dr. Kasamba who's asking, what are the requirements for pharmacies related to ODPC registration and certification as data handlers?
So what happens is not specifically for pharmacists, anyone can be a DPO. So the first step you have to do is you have to be a data protection officer. A data protection officer is the one in charge of your facility or your firm that now entails or ensures that data is consented, there is no violation, and everything is in compliance. There is a website for data protection and where you can become a DPO. There is a certain number, you have to pay a fee of it, and there is some documentation you have to use, and that way you can become the DPO. And if you want to do an external training for further information, we can obviously find it online as well. But I would suggest reading the Data Protection Act of 2019. It has all the information lawfully in Kenya that is needed for us to be able to be compliant.
Thanks for that. The next question is in the context of pharmacovigilance reporting of ADRs and in the case where images are required, do you need consent?
It depends if this ADR, if this ADR has been taken anonymously or the patient information has been recorded. So what happens if the patient information is recorded? From what I have been practicing or what my experience has been, you need to take data consent from each and every entity you're handling where such kind of personal sensitive data is probably used or probably used for other areas for say pharmacovigilance. And it's important to also have a confidentiality agreement on such areas.
Thanks for that. Hope your question has been answered. We have another question from Dr. Fantas who says, is there a legal prescription for disposing previously collected data? And I think just as you answer that, there was one which I think is similar, which is what is the recommended maximum period one can store data before disposal?
Basically, storage of data before disposal is quite differential between entity to entity. As we all know, maybe more than 2 to 3 years we can dispose of the data. However, till the time you're handling this data and whatever data you might be sharing from day to day to insurance holders, to doctors, it's important you have consent for such areas. And what is the first question? The maximum period one can store data before disposal. It depends from entity to entity as long as we are not violating the act.
All right, thank you. There's one from Dr. Geoffrey who's asking if you can please give some highlights on the linkage between the Data Protection Act and the Digital Health Act.
I am not sure about the Digital Health Act. I'm only aware about the Data Protection Act, which I've already spoken today. It refers to the legal and authorized organizational measures that are taken to safeguard the personal data from unauthorized access, misuse, and data breaches.
All right, thank you. But I see he's also asked if we can consider having a having a webinar that will focus on the Digital Health Act. Thanks, Dr. Kwame. I think that's something we'll consider having in the future. Then there's a comment by Dr. Ashil, who says very informative, and I think it surely is a very new opening for pharmacists and very important. But how important is this for the Pharmacy and Poisons Board, and how do you think they should go about it, since it's very new?
I'm trying to locate the questions. I need to read it before answering. Can't find them. How comes you're seeing them and I can't see them?
It's on the Q&A section, the Q&A tab.
Oh, it's in the Q&A. 1 minute.
Yes.
checking.
Just next to where you can share the screen.
Oh, yes, I think I've seen it. Here it is. Oh, okay, yeah. You say, Dr. O'Reilly, okay. So, but how is it important this for PPB and how they should go about it since it is very new? For PPB, basically, the Information Pharmacy and Poisons Board mostly stores our manufacturers' details, our marketing authorization holders' details, and not necessarily all the time they would be handling personal prescription data. And I'm sure whatever information PPB is handling or dealing with has some form of lawfully enforced regulations behind this kind of data stored, because it is drugs that are being registered in Kenya. So Data Protection Act is basically from entity to entity that have direct contact or personal communication with patients, with healthcare providers, doctors, and third parties. That's where data protection comes in, where we can easily have a breach. And especially areas like sales and marketing and order management and credit control areas.
All right, thank you. There's a comment by Dr. Sorej Agawal, who's saying some pharmacies issue receipts with the name of drugs and quantities. Isn't that violation of privacy, because the patient quite often uses that receipt to get a repeat?
The fact that this pharmacy, this patient is using the same prescription to get a repeat of the same product, you see, this prescription is not going to a third party. This prescription is not going to another patient unless and until we have made a mistake somewhere whereby we have wrongly given this prescription to another patient thinking it was for patient X. Now that's where a data breach was done. But if you're using the same prescription to give the same patient, that is not a data breach.
Right, thanks for that.
I've seen another question. I've seen another one.
Uh-huh.
There's an anonymous attendee asking, is there an implied requirement that superintendent pharmacist is the data protection officer? No, as a data protection officer does not have to be a superintending pharmacist. Anyone can be a data protection officer as long as you have understood the law act, the Data Protection 2019 Act thoroughly. And if you Google it or write the how to register as a DPO in Kenya, you will have a display of the registration details, the fees to be paid, and what is required for you to be a DPO.
Thank you. Thanks for that. I think we have a couple of more questions. Is there a prescribed tool to obtain patient consent?
No, there is no specific prescribed tool such as those kind of areas, but depending on the time how you're sharing data, it's obviously important to get them, there's so much of digitalized e-forms that you can get signed. It can be done even like remotely, as long as you have a disclaimer where they've shown to consent for this kind of data to be shared. This is more than enough.
All right, thanks for that. There's a comment by Dr. Kigathi. One of the emerging issues is e-waste disposal, especially in mobile health. Kindly expound on this regarding health apps in Kenya. I think that's more focused to the Digital Health Act.
I've seen another question by Mr. Solomon. How can I get consent from a client that just calls or shares prescription on WhatsApp to be processed and delivered to him or her? Now, for such a scenario, this is something very important, okay? Because I know now everything has become so digital, it is quite important to understand. This is a very tricky scenario. Obviously, how can you get consent for such a situation? I understand. However, the question comes back to us. In a situation like this, it is upon us on how we are doing disposal of such data. How often are we disposing this data? So if you're receiving this kind of information from a patient, it's important if he has WhatsApped you a prescription or he's written to you something like this. It is upon us as an individual on how we are disposing this data. Are you deleting this WhatsApp message? Are you archiving it? Are you like taking a screenshot and sharing it somewhere in an encrypted database? In such a scenario, I would suggest, like, WhatsApp has this new timer policy. Like after a few hours or days or 3 days, things get deleted automatically. You can just have it set automatically to that, so you're not even having a data breach. And automatically your information you received from this patient has been deleted as well. So if tomorrow your phone is with some unauthorized personnel by mistake, and if he does happen to open your WhatsApp, this information is not there.
Thank you, Ashna, for that. There's a comment by Dr. Poonam. In the West, the Data Protection Act also includes handing out information if it's related to crime to the police. Does this also apply to the Kenyan acts?
For this kind of question, I will need more details on what kind of crime and what kind of information is given to the police. Like, I would like to know more information because we are talking about the healthcare facility. So mostly it requires prescriptions, patient information, patient medical history, patient records. And unless and until if it's in a distribution system whereby we are having our MAHs or our third party contact details and personal information.
Right, thanks for that. See another good question. Does calling a fellow wholesaler to assess the creditworthiness of a client amount to breach of the Data Protection Act?
Depends on the kind of information you're asking from a fellow wholesaler. Are you just asking that how is this client? Does he pay on time? That is okay. But if you're gonna ask that what kind of disease does this patient or this client have? What is his medical history? What kind of drugs has he been ordering? Now that is a very tricky situation where we have to be very considerate.
Thanks for that. I think we have one more question. Actually two. One is with regards to the medical representatives. Does it mean that medical representatives should not do prescription audit for marketing purposes? So maybe you can start with that.
I understand this is a very tricky situation for marketing, especially because I have understood this role as well. I know it's important for us to know our drug knowledge and the trends and analysis in the market in order for us to do sales. Yes, this is very difficult because what's happening recently is because we have access to data records directly in the pharmacy to see what doctor prescribed what product. Ideally, to be frank, this should not be allowed, but the best way we can work on this is when the prescription book, whatever information the book has, it would be important to like probably have the patient name and the patient IP number or any other personal detail to just be probably eliminated, and just the prescription or just the drugs, if it was like paracetamol TID, only those kind of information to be written. That would be the ideal way for such kind of practices.
All right, thank you. How can pharmacists ensure confidentiality versus full disclosure for population safety when dispensing to a partner of an RVD patient who doesn't want his status to be disclosed.
I'm looking for that question again. I've lost it a bit.
This one has been posted on the chat. Maybe I can
Oh,
just send it to you
let me.
directly.
Okay,
Or
1 minute.
just
Let
check
me
on
go
your
find
chat
it.
right now.
Just how can pharmacists ensure confidentiality versus full disclosure for population safety when dispensing to a partner of RVD patient who doesn't want his status to be disclosed? The best practice for this, because you know your patients personally, I'm sure, take them to a private room. And I don't think that way we are disclosing any kind of personal information or disease status.
Right, thanks for that. Okay, I see we still have some time, so I think we'll just maybe take 2 or 3 more. What documentation do we need to prove data protection compliance?
That one we will have to read the Data Protection Act of 2019. It has all the information that requires and what is lawfully legal.
Right, thanks for that. There's a question here as well. There are those people who send you images of drugs their family members or friends are using and ask you more information about the same. Is that considered as a breach?
No, as long as you do not have the personal data of that patient, like name, sex, age, and the disease they're suffering.
Okay, so I see Dr. Poonam has given more information about the question she was asking. And she says it includes disclosing personal information, including patient details and prescription details. For example, a drug is prescribed for unintended use in the UK. The Data Protection Act allows you to disclose personal and sensitive information to the police for investigation for the protection of the public. Failure as a pharmacist to disclose such information will make you liable to criminal charges. Does this apply to 2019 Data Protection Act in Kenya?
For further information on such a scenario, it would be ideal because as you have more information on this kind of setting based in the UK, it will be advisable for you to also go through the Data Protection Act of 2019, whereby you will get a better idea if this is actually lawfully legal or not. I wouldn't be in that right place to answer such a question.
Right, thank you. There's one question, as with the ADR standardized reporting templates, is it possible to create legally similar standardized templates for authorization of patients' data sharing in partnership with the relevant agencies?
Yeah, it's possible. What would be advisable is getting confidentiality agreements done, or just having at the end of that form or template to have a disclaimer where we can have a small statement where data is taken and we need your consent, and then you can have a small like check-in box or a signatory.
Right, thank
I've seen another question has someone has written, comment on data protection with regards to online pharmacy or internet practice. Yes, this is quite important because I see a lot of online pharmacy and remote practices that go on. This is very simple at the end of the day. If you're having an application you're using for, let's say, ordering prescription, posting of prescriptions, and then you can process the order in your app, if it's possible to implement a strategic way of consent, that one they just have to do is read the consent, give consent, check yes or no, and that is consent given to you. And that is the best practice we can work on. I think we are good to go now.
Yeah, Yeah, I see just a comment from Dr. Ruben Mogoi, who says, as per the 2019 Data Protection Act, no consent is required for pictures taken in public social gatherings like churches and clubs. All right.
Yeah.
Have you noted any other question that you've not
I
responded?
think the other questions we can probably just email it.
Okay. All right. So thanks a lot, Dr. Ashna, for that presentation. I think it was very informative, and we've all learned something out of it. For those who've missed out on any part, we'll be sharing the recording, so at least we'll be able to catch up with the information that you've missed out on. So maybe, Dr. Ashna, I'll just allow you to give a closing remark in just a minute, and then maybe Dr. Liber, you can also say something as a closing remark, and then we call it a day.
Okay, thank you, Dr. Hazran. Thank you everyone for hearing me out, and I hope I have been able to fully explain to you all about the seriousness of data protection, especially when it comes to patient handling, or be it when we're in distribution where we are handling the order management systems, or whether we're in sales and marketing. I am also, this opportunity was given to me on board. I had no idea what this was. It took some time, learning, experience, training, consultations is when I have somehow understood this. And I would like every one of us to also take this seriously, because I've already shown you two situations where companies have been fined and because of data violation. Obviously, us as individuals, we don't do this purposefully, but because of the awareness we are lacking, is because of this we are having data breaches that are becoming very common over this year, which I have seen because I read a lot of newspapers regarding this. Otherwise, thank you everyone for hearing me out. I hope I can make a difference out there. Thank you.
All right. Thank you, Dr. Ashna. Dr. Liber.
Thank you. Thank you, Dr. Hezron, and thank you, Dr. Ashna, for such an insight-filled presentation. On behalf of Legal and Ethics Committee, mine is to pass appreciation for tuning in for tonight's webinar. I want to believe that you've been enlightened and you're at a better position as far as handling of patient data is concerned, or any identifiable data is concerned. Our delight is when we as colleagues are able to practice within the confines of the law, especially with the emerging bills. We've been seeing colleagues or businesses being fined lately, and we don't want more of us falling into that particular trap of being found on the wrong as far as Data Protection Act is concerned. And such platforms come in handy to enlighten us. I've seen a request on digital health, and I'll pass the same to the Legal and Ethics Committee through Hezron and the PSK Secretariat to see if you're able to have a session on that and many other areas of concern that you may want to get insight on. So please feel free to also channel your requests on sessions you would like to have, or you like the Legal and Ethics Committee to convene webinars to enlighten members. In the Legal and Ethics Committee, I serve as in charge member education, matters legal and ethics. So feel free to channel the request through me. I'll be able to pass it to the committee so that we can set up sessions such as this to enlighten you. Thank you so much. Over to you, Hezron.
All right. Thank you so much, Dr. Liber, and also for the committee for sharing this for assisting with the organizing for this activity. I think it's very important for members to continuously learn on the emerging issues. So for members, as we close, I'd just like to remind you about the Kenya National Pharmaceutical Policy. We had done a webinar 2 weeks ago together with the DHPT and Africa Resource Center. And if you checked your email and the WhatsApp group, we had shared a link where you can view the national pharmaceutical policy. And aside from that, you should have been able to see the situation analysis that was done. And right now, you're required to submit input on the policy. So we're encouraging you to kindly do so. We only have up to the end of the month to share our feedback. So far, we've received a few feedback from some of you. So I'd like to encourage you, if you haven't, kindly review the policy, review the situation analysis that was presented by the DHPT team, and share your feedback. So if you just have a look at the chart, I've shared the link to where the policy is, the situation analysis, and where you can share your input. And you'll also be seeing this more and more in the WhatsApp platform so that at least you can get full feedback from all the members. So at this point, I think we'll end our session. Once again, thank you to Dr. Ashna, Dr. Libert, and the entire Legal and Ethics Committee for facilitating this session. So without further, I see we don't have anything else. So I think at this point, we'll just close the meeting. Thank you so much for joining. Dr. Emmanuel, I think maybe you can share with us your email address. You can just send a message to communications@psk.or.ke and we should be able to add you to the WhatsApp group. So I'll just type in the email on the chat and then you can reach out so that we add you to the group. So Dr. Emmanuel, I've sent the email on the chat, send the request there, and you should be able to add you to the group. So this is where we end. Thank you all for joining and have a good night.